himself apologising for that at the very least. I call the Honourable Michael Woodhouse.
Mr Speaker, I was quite sure I saw a discernible shudder from Willie Jackson when at the revelation that he was sitting beside a capitalist, albeit a responsible capitalist, as Mr Mitchell claimed himself. He then went on to decry the neoliberal experiment of the last 30 years. But one of the things about going in this order, in this slot, is that I don't get the opportunity to hear from the Honourable Willie Jackson before I retort, because I know exactly what he's going to say. He's going to portray employers as villains and employees as victims, and there'll be some tub-thumping 10 minutes about how this is the right thing to do and how bad employers are. Because we've heard it before. What he's really saying, actually, the really sad part of that, and I predict we will hear this, is that what I hear in that message is that employees are too weak and too stupid to actually negotiate with their employers in a mature and respectful manner. Because that's what I think we have at the moment in the employment relations landscape in this country. And not all employers do the right thing by their employees. But that's the exception, not the rule. And what we see in this bill is an underlying philosophy of employers are the villains and that being the rule. And I'm very, very disappointed to note that because the overwhelming number of employees do the right thing, and that inference is a stain on them and their efforts in being the backbone of this economy. And in my 3 years as Minister for Workplace Relations and Safety, I did at least the two things that Mr Mitchell mentioned, fairness and flexibility, and I want to give examples of that, but also safety. And I think the passage of the the Health and Safety at Work Act 2015 was a really important milestone that the previous government saw as very important in our employment relations landscape. But it wasn't just that. In fairness, it was increasing the penalties for non-compliance by employers to make very clear that that sort of behaviour wasn't acceptable. It was suspending their access to the international labour market if they breached employment law. And it was, of course, the reality that if they themselves were recent migrants, they could be liable for deportation. The 0 hours legislation was passed with the unanimous support of every single member of this House. That was a very important national-led amendment to protect employees from poor practice. That's a very good point, Mrs Dean. Not a single word about that in the 12 months that they have been in government. And flexibility, though, I think that's where the saddest part of this bill comes in, because it reflects a completely jaundiced view of why certain things are necessary. I want to start with the 90-day trial, because not a single Labor-led government member has actually explained why, prior to the sensible changes the key English government made, New Zealand was the only one, if I recall rightly, there might have been two, but at least no more than 2 countries in the OECD that did not have a 90-day trial. And some of those countries, Mr Speaker, were some of the most socialist, leftist governments in the OECD, and they saw the 90-day trial as fair and flexible. So if they do, if Turkey does, if Australia does, if the United States does, if most of the Eastern Bloc countries, all of the Eastern Bloc countries that are members of the OECD, think that's a very good idea, why was it such a terrible thing for New Zealand to have it? And the answer, of course, is that it wasn't. We started with small business, we extended it to all business, and I defy anybody to put substance behind the interjections of Ms Lubeck that somehow that was bad for employees. The marginalised, the returning to the workforce, the recent migrants have all benefited from that. And they will talk about the number of people for whom the 90-day trial didn't work out. They don't talk about the overwhelming tens, if not hundreds of thousands of employees that were given a go coming out of the global financial crisis when they otherwise might not have had that opportunity. And I do credit New Zealand First with at least putting back the small business exemption to the removal of the 90-day trial. I say, if it's good for those businesses, it's good for all businesses. Now, the other one that really upsets me, disappoints me more than anything, is the rest and meal breaks one. And I've used these examples in the House. See, they laugh. They think it's funny. They think it's funny that we don't think employees are too stupid to negotiate for themselves flexibility in their shifts. And I'll give you an example of that, Mr. Speaker.
Don't take it seriously.
As some members know, I used to run a surgical hospital, and in certain times of the week, the ward at night was not busy enough to justify more than 2 registered nurses. In fact, sometimes it didn't justify that. But for clinical safety reasons, it's necessary to have 2 registered nurses on a night shift. Now, the definition of a rest or meal break is one where a staff member is able to leave the ward. That is not possible under those clinical conditions, and therefore I paid a generous allowance and gave them a meal so that they were compensated. No, they can't. That's the point. They simply cannot. They can negotiate the timing of their rest and meal breaks, but they cannot negotiate it away. And indeed, in the morning shift, because shifts in hospitals traditionally, and NZNO still haven't been able to negotiate this away, I hope they do redouble their efforts, but they're actually very, very bad for working parents. Most of them are women. The morning shift starts at 6:45 and it ends at 3:15. Now, I had arrangements with some of my staff to enable them to leave early. As long as the handover of patients was done, they could leave if they didn't take a lunch break at 2:45 instead of 3:15 and be ready and available to pick their children up from school. That's unlawful.
Flexible.
And actually, rather, I will, on one point, it may be possible to schedule the lunch break for 2:45. But technically, again, they can't leave the ward. The point is, why did we need this? Because when it was unacceptable, when it was inflexible, when the employers were not doing the right thing, there were already provisions to protect employees from that. And frankly, the unions would and should and were doing their job of that. But the problem is we have an attitude of villainous employers, none of whom can be trusted, and therefore that kind of flexibility has to be rooted out of the bill. It's a crying shame, Mr. Speaker. Now, I want to go on to access to the workplace. In fact, I was fascinated to hear Mr. Mitchell say that this was some kind of watering down of this because Section 20A now, as a consequence of the SOP the Minister has introduced, suggests that the union representative must obtain consent to enter the workplace, and indeed that's what it says. But the exceptions to that are not just if there is a collective employment agreement in place. It's also, at the time of the representative's entry into the workplace, the union or employer has initiated bargaining and the intended coverage of the collective agreement is set out in the notice given in accordance with Section 42, covers the work done by employees at the workplace. It doesn't say that the workplace is going to be covered by the collective agreement, and indeed this could well be a place where the unions want to extend the coverage, but we now have a provision that says there is an opt-out provision in the MECA, and it's far from clear to me whether or not this change is completely obsolete in the sense that if the union intends and hopes and is trying to get an extension of the coverage to that workplace where one presently doesn't exist, they nevertheless don't have to seek permission to enter the workplace. So I see this as a Clayton's watering down. It is actually a stalking horse for the lack of permission that I think a respectful union will continue to do even though this law is passed, and I'd like to think that they were overwhelmingly in that space. But don't think for a moment, members of the House should not think for a moment that this amendment in the SOP is something like akin to a watering down back to what the present Employment Relations Act says. Now, the last thing I want to touch on is the issue of partial strikes, because I don't believe there's been any change to that. I wasn't on the committee at the end of the process. But we have partial strikes going on in hospitals right now with midwives, and they are taking 2 hours off per shift between the 22nd of November and early December. Now, when the Minister was confronted on this in January, when the framework was announced, he talked about partial strikes as some kind of protest thing, and he used the Wellington Free Ambulance workers wearing red shirts at work and somehow being at risk of punishment, and that was a bad thing. Well, of course, that's not any sort of definition of a partial strike. What is these 2-hour breaks, and the employer will have to pay for that every single time they do it it will become the norm. We'll speak more about this in the Committee of the Whole, but there is very, very little redeeming about this legislation.
I call Jan Logie.
Tēnā koe te mangai o te whare.